Family law, the branch of legal practice that deals with domestic relations, that is, matters relating to marriage, divorce, support, custody, and adoption, is known as family law. In legal usage, the term family is broadly defined as a group of persons living under one roof and under the authority of one chief person or head. Within the broad definition, you can see that the legal definition of family is not restricted to biological parents and their children. In resolving property and inheritance issues, the term family often refers to persons sharing descent from a common ancestor. Most issues involving domestic relations are brought before a branch of court known as family court. The jurisdiction of family court varies from state to state. Some areas, family court may hear only cases involving marriage and the dissolution of marriage. Other courts may hear cases involving injuries to children or crimes involving children. Marriage. Under the current law, the term marriage refers to the legal union of a man and a woman as husband and wife. The state of marriage is often legally referred to as wedlock. A person joined in marriage is legally defined as a spouse. Spouses enjoy a range of legal rights not generally available to couples who are not married. Such rights include protection of property, provisions for financial or marital maintenance or support during the term of marriage and afterwards, and rights of inheritance of personal and real property. The right of one spouse to use and enjoy the other's property is known as courtesy. In addition, upon entering wedlock, both spouses agree to uphold specific rights and duties in relation to each other, legally referred to as the rights and duties of consortium. This collection includes companionship, love, affection, assistance, comfort, cooperation, and sexual relations. Loss of such duties through injury or choice is known as loss of consortium. Marriage is a legal contract binding upon both parties until death of one party or until the contract is legally dissolved under statute law. The law prohibits marriage between close blood relatives, such as siblings or parents and children. The law also forbids bigamy, the attempt to enter a new marriage contract while still legally married to another person. Bigamy is defined by statute as a crime. Most states require officially designated authorities to solemnize marriages, that is, to join the two parties together in front of witnesses by performing a formal ceremony. A solemnized marriage is often called a ceremonial marriage, while performance of the ceremony itself is known as the solemnization of marriage. Marriages must be solemnized in a formal ceremony in most states. Such ceremonies may be performed by a justice of the peace in a civil ceremony, or may be performed in a church by a member of the clergy, that is, an ordained minister. Entering into a valid contract of marriage typically requires several legal documents. Prior to the solemnization, parties wishing to marry must obtain a marriage license under statute law, which is a formal state authorization allowing the couple to marry. In certain states, blood tests for certain diseases are required before a license may be obtained. After the ceremony, a marriage certificate is used as proof that the marriage has been formally solemnized. The certificate is typically signed by the person who performs the ceremony, the spouses, and the witnesses to the ceremony. In addition to obtaining the documents authorizing and evidencing marriage, many couples enter into an additional contract, known as a marital agreement. This additional contract establishes financial and property arrangements between the spouses during the marriage or in event of divorce or death. Most marital agreements are entered into prior to marriage, in which case they are known as prenuptial agreement or an antenuptial agreement. Agreements entered into after marriage are known as postnuptial agreements. A marriage that has not been solemnized through formal ceremony is known as a common law marriage. Many states, being corporations, do not usually recognize the validity of common law marriage, although in a court of law they must respect its solemnity. Where such arrangements are recognized, common law marriage has the same legal effect as a ceremonial marriage. In order to enter into a common law marriage, the couple must mutually meet three conditions. One, they must live together, legally defined as cohabitation. Two, they must verbally affirm to each other their vows and that they are married. And 3, they must present themselves to the community as husband and wife. And 4, it is wise to record this in a holy Bible, which is a legal document. Dissolution of marriage. There are 3 common ways to legally dissolve a marriage. 1 is annulment, 2 is separation, 3 is divorce. An annulment of marriage is a court order or decree declaring that no valid marriage ever existed. The primary grounds for annulment differs from state to state, but commonly include the following. 1. Void marriage, marriage prohibited by law. 2. Duress. 3. Fraud. 4. Pregnancy by someone other than the husband. 5. Incurable venereal disease. 6. Mental illness at the time of marriage. 7. Physical incapacity. And 8. Bigamy. The court may also order a separation of spouses, also known as a divorce from bed and board. Separation does not terminate the marriage contract, but rather formally recognizes an end to cohabitation and determines issues relating to property, support, and children. Separation is usually accomplished by decree or by filing a document called a separation agreement with the court, or at least having it evidenced somewhere in the house or in the possession of each party. Many states require separation for a specified period of time before certain divorce actions can be initiated. Formal termination of a marriage contract is known as a divorce, and in some states as a dissolution of marriage. In order to be valid, a divorce must be decreed by the court. Divorce may be granted on a number of grounds, including 1. Fraud, 2. Duress, 3, which is really the most legitimate one, adultery, intimate relations with a person other than the spouse, and 4. Cruelty, infliction of physical or mental pain or distress, and 5. Desertion, a willful permanent departure of one spouse without the consent of the other, or without having been wronged by the other. And number 6, alcohol or drug addiction. Number 7, failure to provide support. And number 8, the felony conviction of one spouse. A decree that dissolves the marriage contract due to the type of misconduct described above is known as an absolute divorce, or a divorce of vinculo matrimoni. The defendant in a divorce action may argue that the spouse initiating the action forgave the conduct introduced as grounds for divorce. Such forgiveness is known as a condonation. Alternative defenses include connivance, an argument that the spouse suing for divorce assisted in the accomplishment of misconduct. 2. Recrimination, an argument that the spouse bringing the suit is also guilty of conduct that serves as grounds for divorce. Most states have enacted no-fault divorce statutes, which allow the dissolution of marriage without introducing fault. In some states, divorce can be granted on the basis of incompatibility, a profound personality conflict that offers no hope for reconciliation. That is, a renewal of friendly relations. Dissension and conflicts of personality that have undermined the marriage relationship beyond reasonable expectation of reconciliation, legally referred to as irretrievable breakdown of the marriage or irreconcilable differences, may also serve as grounds for no-fault divorce. Before the widespread enactment of no-fault divorce laws, people would sometimes travel to another state or country to obtain a foreign divorce. Common reasons for seeking a foreign divorce included the absence of grounds for a divorce as stipulated in the home state, or a desire for an immediate divorce without a waiting period. For many years, Nevada was one of the most popular states in which to obtain a foreign divorce. Divorce often requires resolution of certain financial and property issues. For example, an allowance for support and maintenance, known as alimony, is usually awarded to the divorced spouse and must be paid in regular installments. In determining the amount awarded, the court will take into account several factors which vary from jurisdiction to jurisdiction, but usually include a spouse's ability to earn money, a spouse's need for money, and a spouse's ability to pay, the accustomed style of living, and each spouse's assets and liabilities. Some states allow a form of alimony known as palimony to be awarded following the termination of a common law marriage or other long-term cohabitation. Alimony and other support payments past due are said to be arrears. The ex-spouse to whom payments are in arrears may take legal action to collect the money owed. However, following a divorce, neither spouse is responsible for any support payments that were especially under a separation agreement. Such payments are canceled and replaced by an alimony award through a court action known as merger in judgment. Issues involving shared property, usually referred to as community or marital property, must also be resolved during a divorce proceeding. Community property consists of earnings or property acquired by either a husband or wife during the marriage, which in some states are held to belong to both spouses equally. Real property is often split into separate lots by a deed of partition. Gifts and inheritance made to either spouse are usually accepted from the community property rule. The division of community property can be a complicated and painful process. Certain states allow the court to distribute all community property on a fair, equitable basis, commonly referred to as equitable distribution. In determining an equitable distribution, the court usually considers such factors as the length of the marriage and the contributions of each party. Issues involving children. Parents are legally obligated to contribute to the economic maintenance and education of each of their children. Financial contribution for this purpose is known as child support. The term child isn't strictly defined by the courts, but is usually considered synonymous with the legal definition of an infant. In a divorce proceeding, the parties may set the amount of child support by agreement, subject to approval of the court, or the court may determine the amount. Support may be demanded from a child's biological father, even if the parents are not married to one another. The man sued for support may deny paternity, the legal term for fatherhood. Such cases, a legal action known as paternity suit or affiliation proceeding may be brought in order to establish paternity and compel the father to pay support. The court typically orders a test for similarity of human leukocyte antigens known as HLA test in order to determine paternity. Another issue commonly debated in a divorce is custody, the care, control, and daily maintenance of a child. To help decide this matter, the court considers several key issues, including 1. The financial, physical, and emotional soundness of the parent seeking custody, 2. The physical well-being of the children, and 3. The emotional, social, and economic well-being of the children, and 4. The children's own wishes. Temporary custody of a child is often granted to one parent on a short-term basis, pending the outcome of a divorce or separation action. Ultimately, the court may award the sole custody to a single parent. Such cases, the other parent is usually granted visitation, the right to spend time with the child at times and places agreed on by the parents or ordered by the court. Alternatively, a court may order divided custody, in which case the child would live with each parent for part of the year. While the child is living with one parent, the other parent is usually granted visitation. The court may also order joint custody, an arrangement by which both parents share responsibility of maintenance and education and jointly make important decisions about the child's welfare. In joint custody, the parents each share responsibility for making decisions concerning the child, while in divided custody, the parent with whom the child is living has complete control over the child during that period. In joint custody situations, the parent with whom the child primarily resides, as we said, is said to have physical custody. Custody issues have become the focus of intense debate in cases involving surrogate motherhood, the term used to describe a woman who agrees to carry the child of another woman or of a man who is married to someone else. Agreements between married couples and surrogate mothers typically require the surrogate to assign her parental rights to the couple for whom she has agreed to bear a child. However, some surrogate mothers have successfully brought suit to obtain sole custody, joint custody, or visitation. Another issue of concern involves one parent abducting a child in the custody of the other parent. This act is known as child stealing or parental kidnapping. Is considered a crime. A parental kidnapping incident can arise from the suspicion that the custodial parent is harming the child. Bringing physical, sexual, verbal, or emotional harm to a child is a crime known as child abuse. Neglect is also considered child abuse. State statutes, known as Child Abuse Reporting Acts, legally obliged doctors, social workers, teachers, and other health or public officials to report suspected incidents of child abuse. In child abuse actions, the court may appoint a close relative or public employee to act as guardian ad litem to protect the child's interest during litigation. A guardian ad litem may also be appointed in situations where the child's parents are deceased or incapacitated. In some states, child abuse cases are tried in juvenile court, which has jurisdiction over matters relating to children. The term juvenile refers to all children under the age of majority, that is, under 18. A juvenile offender, for example, is one of the legal terms used to describe a child who breaks the law. Juvenile court may also have jurisdiction over placing a child temporarily in the home of an adult or family unrelated by blood. Temporary placement of this sort is commonly referred to as foster care. A child placed in foster care is known as a foster child, and each adult charged with temporarily providing care is known as a foster parent. A child may be placed temporarily in foster care in certain situations, such as when the child has been a victim of abuse or neglect. Permanent establishment of a parent-child relationship by process of law is known as adoption. Adoption is a legal process in which responsibilities and rights are transferred from the child's biological parents to his or her adoptive parents. Adopted children are thus legally enabled to inherit property from their adoptive parents. Under the doctrine of equitable adoption, a child may legally enforce a promise to adopt him or her, at least to the degree that inheritance rights are guaranteed by the person who made the promise of adoption.